Right, okay, let me make a start to this, and I'll go through some of my remarks, and then obviously we'll go to our speakers. Thank you very much for signing up to the first of this series of shared parenting webinars. Our international tour starts very close to home. We're looking at proposals for changing the family courts in England and Wales. In subsequent sessions, we will travel to Sweden, the Netherlands, Israel, Canada, and the United States to hear about changes that have been introduced in these countries and consider whether they could work in Scotland. We're very grateful to the Scottish law firm Harper Macleod, who have sponsored this series on the basis that it will be invaluable for all practitioners in the field of family law to understand what other jurisdictions are doing to improve and protect the well-being of children and parents living as separated families. We also have Amanda Masson from Harper Macleod as the respondent to Helen Adam's presentation today. I'm Ian Maxwell, I'm the National Manager of Shared Parenting Scotland. Although we have confirmed all of our international speakers, we're still sorting out some of the dates and also arranging appropriate Scottish specialists to provide the responses. The next book session is a talk by Malin Bergström from Sweden. That's on the 19th of October, but we'll send out the full program as soon as all the dates are available, so you'll get that in due course. All the sessions will be recorded and made available on our website, along with links to background information, and we'll send out copies of today's PowerPoint after the session. At Shared Parenting Scotland, we're doing two main things. Our helpline, local group meetings, website, publications, WhatsApp groups, and training program are all intended to support the many separated fathers, mothers, and other family members who contact us. Our other objective is to campaign for better support for separated parents and their children, to help them deal with the consequences of separation, and to keep both parents fully involved with their children wherever that's possible. The Children Scotland Act 2020 and the Family Justice Modernisation Strategy, once they are actually implemented, will make some positive changes in Scotland. But we believe that a far more fundamental transformation is needed to take much of the dispute resolution out of the courts, to provide support more quickly and less expensively, and above all, to put the interests and the needs of children uppermost. Most of today's audience are family lawyers, and I want to reassure you, we're not actually trying to destroy your jobs. We're suggesting that the emphasis should shift from adversarial court action to supporting your clients through to decision-making and dispute resolution process that will be far less damaging both to them and to their children. So let's use the questions and discussions this afternoon to explore these possibilities. Our main speaker today is Helen Adam, who started as a family lawyer. Seems to be lots of people start as family lawyers and then move on to be mediators, but that's an interesting quirk. Helen is now a senior mediator and one of the foundation trainers for the Family Mediators Association in England and Wales. She lectures regularly on family mediation, including training new family court judges at the Judicial College. Helen will be talking about what has been happening recently south of the border in response to the What About Me report, which was published in November 2020 by the Family Solutions Group. Helen chaired that multidisciplinary group of professionals, which was set up by Sir Stephen Cobb in 2020 to consider what can be done to improve the experience of children and families before any application is made to the family court. I think that's a really important thing. It's trying to deal with people on the gangplank rather than aboard the ship. Which was the analogy that the head judge in England made at a recent meeting. The report included some powerful messages from children whose parents live apart. One of them is, when the separation happened, I was really shocked, angry, confused. I didn't really know how to react as I hadn't seen my dad so upset before. I didn't know where to turn. We'll include a link to a short video with more of these children's views in our follow-up email. We would have liked to have played it today, but we couldn't get a good enough quality sort of reproduction of it on the webinar. So let's now move to Helen, who will tell us what is happening as a result of all that work. Can you use the question and answer to pose any questions or comments as we go along? because that will allow us to, and then we will pick up on the questions and comments once Helen and Amanda have finished speaking. So that's the way to interact with the webinar. So I'll hand over now to Helen to share her screen and her PowerPoint.
Ian, thank you very, very much indeed. And thank you for inviting me to come and launch this series, World Series. It sounds terribly grand, the World Series, looking at what different jurisdictions are doing to come alongside families when they separate and manage the process better. So I'm going to share my screen now. Here we go. Beginning. I hope that's clear to see. I'm doing this from Kent. I have to say that my working life has always been down here in the south, but my heart is always in Scotland. My father grew up in the west coast, in a little village near Fort William, and we go up there regularly. So it's lovely to be doing something in Scotland professionally for the first time ever. This is called Changing the Court Processes in England and Wales. And really, the focus is actually how to change the process as people come towards court, rather than once they get into court. There is a general consensus here that too many parents are ending up in court with problems that needn't be in court. And so the focus of the Family Solutions Group and the work that I've been involved in is in how to come alongside families and direct them to the needs, respond to the needs that they have, to the right support. And clearly there are going to be those where there are safeguarding issues or other vulnerabilities who need the court process and should be there. But this is largely addressed at those families who have fallen out and for one reason or another end up in court. And really, how can our systems operate better so that those families get the support they need without making things worse with hostile court proceedings? So the reforms have a sort of starting point in 2018, when the President of the Family Division set up the Private Law Working Group to review the Child Arrangements Programme, which is the terminology that we use for any application in England and Wales concerning the arrangements for a child. And they published their report in May. There was consultation periods. This is through 2019. And then the final report was published in April 2020. It was called The Time for Change, The Need for Change, The Case for Change, which I think is quite strong language from Sir Stephen Cobb, who chaired the Private Law Working Group. I was the mediator member of that working group amongst a very impressive array of judges, civil servants, academics, all of whom have a full lifetime experience of professional work in the court system. And I said to Stephen that if the idea was to catch families before they ended up in court, then there needed to be a different group of professionals around a table who have experience of working with families outside of the actual court process to understand their needs. And it's one of those classic conversations where you say, this is what needs to happen. And he said, great, that's great. Can you set that up and chair that? And it's off his desk. So we pulled together a multidisciplinary group. He said he would like it to be called the Family Solutions Group. And we worked throughout 2020 to come up with our report, which we called What About Me, with a picture of a child on the front. And it was about reframing support for families following separation. Before we came up with our report, though, the MOJ published a report which had been some time in the making, the Risk of Harm Panel report, and that was addressing the concerns highlighted by an awful case, but then again highlighted in both the Private Law Working Group reports about the failings in the system for victims of domestic abuse and the changes that were needed. So basically, a combination of these reports all had strong calls for change. Victims of abuse were not being safely managed, and the system was broken and putting them at further risk, potentially a further risk of abuse through the court system. The different professionals involved with families were all working in silos. There was no integration. There was no coordination. It was very confusing. The system that was set up to try and direct families towards mediation was not working. So just in a nutshell, so you know, we have here in England and Wales a system where when somebody wants to make an application to court, they are expected to attend a MIAM. And a MIAM is a mediation, information and assessment meeting. And it's a one-to-one meeting with a mediator. And the idea is that instead of just issuing an application, you go and see a mediator, you talk through your issues in confidence, and if mediation is suitable, then the other person is invited along, and then you both mediate and the case is diverted. In practice, the system was thoroughly broken for a number of reasons, one of which, a key one being that you know, mediators can't get mediation off the ground if they only ever see one person, and many of the second people in the issue wouldn't come. So there were a number of problems, but basically the narrative was MIAMs don't work, mediation doesn't work, and we need to have a radical rethink. So what has been the response to all these various calls for change? And that's really what I'm going to be looking at. So first of all, the Ministry of Justice set up some Pathfinder pilots. They established a group, a reform group in 2020, and they worked over quite an extended period, a year and a half, to put together a pilot which would offer an integrated approach with information sharing between agencies and with a greater emphasis on investigation rather than confrontation. The idea would be for it to be much less adversarial, to use different language, and to be more of a problem solving, all the professionals gathering around and problem solving. And I'm delighted that there was a really inspirational person from the Nuffield Family Justice Observatory who was on this group, constantly calling for the voice of the child to be embedded at every stage. And so there is an emphasis on getting the children consulted and their views taken into account in the process. The MOJ have worked for some time to pull off these pilots, and eventually they were launched only in March this year. The plan was to roll them out across the country, but there's been such an enormous amount of work gone into getting them off the ground that they're waiting to see how they go, these two pilots. One's in Bournemouth, the other in North Wales, and we'll review. But the aim, I think, is subject to the data, is to make all family courts modelled on the Pathfinder model of a more investigative and less adversarial process. However, the point that was important for us on the Family Solutions Group was that these pilots make no provision at all for anything upstream of an application to court. That's the MOJ terminology. Their responsibility starts at the point that an application is made. And so there was nothing built into the budget or the planning or anything to reach families with information or guidance or signposting before that application. So we wait to see how the Pathfinders develop, but it's not catching people before their initial application to court. However, following the pandemic and with a real crisis really in the numbers turning to court and the backlog, the then Lord Chancellor, Sir Robert Buckland, introduced the mediation voucher scheme in 2020. Actually, I think it was launched in 21, but he came up with the idea in late 2020. And the idea is of a contribution, non-means tested, an automatic contribution of £500 towards mediation costs if any issue concerning a child is discussed. So that was launched with the idea of it just going for a short time and then being reviewed. But it has continually been extended. And in fact, the latest vouchers, there's now been over 10,000 mediation vouchers issued. And the findings are that around 75% of cases are having either all or partial issues resolved. But what's also very interesting is that the data suggests that around 50% of those who go to mediation and use the voucher say they would not have opted for mediation had there not been the voucher. scheme in place. So it is definitely working in the sense of diverting some families into mediation. The scheme is now going out to tender as of March next year, and we take that as quite an encouraging sign that it is likely to be extended. Oh, can you see that? My screen has just, can you still see the PowerPoint? My screen has.
Yeah, it's still appearing.
Is it still there?
Yep, on the Pathfinder.
It's appeared off my screen. Oh,
Okay.
okay, I'm back on it.
Good.
Sorry, I have some notes on my laptop. Something must have touched something. Yeah, we think it's encouraging. I'll go back to where we were. We think it's encouraging that it's going to be going out to tender. I think it suggests it's going to carry on. The other thing which they've done very recently, and I think this was following a change in government, is that they put together a small group called the Private Family Law Early Response Working Group in August 2022. It was following Boris's planned resignation and before the new leader, the Prime Minister, took effect. So there was a kind of blank time, and the MOJ get the prize for the longest working group names. Anyhow, they put together this group with the focus on reviewing MIAMs and revising the exemptions for MIAM so that more cases would be able to go to mediation. It had a slight setback in that the group that they put together didn't include anyone who was a mediator, but the Family Mediation Council, I'm delighted to say, were then invited to join with a representative who became very involved in looking at the dynamics of why families opt in and opt out and how the exemptions work. So that has been helpful. They've also, the FMC have also addressed some concerns that the Private Law Working Group raised, and I don't know if you have a similar thing in Scotland, but basically there was concern that there aren't enough mediators. There was concern about different mediation governing bodies dealing with complaints differently, but also that there weren't established MIAM standards, and so you've got MIAMs being delivered in all sorts of ways, you know, and perhaps not comprehensively by different practitioners. So the FMC have now issued their standards. We now have them dealing with all complaints as the overarching governing body, and they say there are enough mediators. And I think all of this has been very reassuring. We are really trying to push child inclusive mediation. And following some good research that came out from the University of Exeter earlier this year, that's opened up the possibility. But here I'm slightly ashamed to say that as yet we do not have public funding for young people to be consulted in mediation, and it's something that we in the mediation community are longing to see. But you know, all of this is encouraging noises about finding ways to ensure that those cases which are suitable for resolution outside of a court process are getting there. There's a shift in narrative. When I think of what was going on in the Private Law Working Group, we now have the Justice Minister due to deliver a speech next week at our annual conference, and he has called it the government's initiatives to promote mediation, family mediation. And the President of the Family Division is also giving a speech next week, and he's called his relaunching family mediation. So there's been a lot of energy and effort to do what can be done to ensure that those cases suitable for mediation get there. But I would say, even though I am a mediator myself, is mediation the complete answer? And the answer is, well, that's great to promote mediation, the move is welcomed, but no, mediation is not the complete answer. For some, it is quite clearly not going to be suitable. And so what other initiatives are needed? The Family Solutions Group, we came up with a whole load of recommendations, far too many really. And I'm just going to sort of give you just an overview of the other areas that we are pushing for in England and Wales for these to be addressed. We published the report in November 2020, and in fact the President of the Family Division said it was the most exciting thing that had happened in family law for a very long time, because for the first time we were looking at the needs of children, young people and their parents outside of the context of law and justice, but in terms of what do they need following separation. So we had various key headings. We call for political oversight and coordination. We badly lack that here. We have a Minister for Children who sits within the Department for Education, but there's a long list of responsibilities which does not include the needs of children from parents who live apart. There is no coordination to ensure that those needs are met. They fall between the Ministry of Justice, Department for Education, Department for Health and Social Care. The one department that's actually doing some really good stuff is the Department for Work and Pensions with the Reducing Parental Conflict programme. But otherwise, there is no specific place that it falls within government to address the needs of families following separation. And so if the only provision being made is the open door of court, that's where they end up, because that's where the provision is. We call for public education, and there is a terrible misunderstanding about how the law operates here and what the law expects when families separate. We still regularly hear the term custody, which went out for us with the Children Act in 1991, and yet custody battles are still very much in the kind of cultural language. We say there should be a very early assessment of needs, early information provided, an assessment of needs, so that family needs can be triaged and they can end up with the signposted to the right support that they need. And those support services must include direct access support for children and young people. At the moment, we have none.
Helen, can I just, your slides, I think, have got stuck at the Pathfinder's pilot slides. I think.
Oh gosh, I'm on a totally
yes,
different.
I know you're.
So sorry.
Yes, I'm sorry. I should have picked this up before.
So now I'm going to stop share.
And if you can try
and
reshare.
I'm going to share again.
Yes, try share again. Yeah, sorry, sorry to catch you off in mid-flow.
Is that better?
Yeah, that's now going. That's a different slide. Do you want to go back? You had the one that we were stuck on was the one about the Pathfinders. Yes.
Oh, that was a long time ago.
Yes. Okay.
This one.
let's just recap very slightly, but we don't want to repeat the whole thing. But just
no, I won't go over. So that was the one about the Pathfinder.
Okay.
There's no provision. That was the key thing, really. There's no provision for anything upstream. And then we've got this is the mediation voucher scheme that I referred to. Really encouraging. We've got the early response working group that looked at mediation exemptions and how to improve the numbers turning to mediation, hopefully get some child inclusive mediation funding. And this was the shift in narrative, very encouraging. It's all about family mediation. But I then said, is mediation the answer? To which, great to promote it, but no, it is absolutely not the answer to everything. And quite clearly, mediation is inappropriate for a number of families. So this was our report, the most exciting thing that's happened in a very long time. And I was just sort of referring to the areas of recommendation in our report. So I covered the political oversight, of which there is none, the need for public education, the need for early information and assessment of needs, direct access support services for children. We also need access to separated parenting programs. It's something which is mandatory in many jurisdictions around the world, but not only is it not mandatory here, but it is little known. And so as a mediation practice, we have our own separated parenting workshops. We find it really difficult to get our clients to sign up. It's not something that's kind of known or understood. So, you know, a national database of programs that are accredited to establish standards, I think, would be really helpful. We need appropriate language throughout the system, and I'll come back to that in a minute. And we need holistic working practices. This is, you know, we don't want everybody working in silos. Our clients have multiple needs. They do need, many of them need legal advice, and we need our lawyers to be giving them that advice, but also recognizing the other needs that they have. And, you know, the need for child consultation where there are teenagers, you know, the need for psychological support, the need for some parenting support. There might be, you know, there's a range of other needs. I think there's a industry of divorce coaches that are growing up here. I assume it's the same north of the border, but you know, parents and those separating have multiple needs. These are not just legal issues, and we need holistic working practices. So I just wanted to mention, these slides will be coming out to you, I believe. I wanted to mention this new training that's just been launched, actually only as of Monday it's just been launched. It's called Reflex Training, and it's essential skills training for family lawyers of all levels, from a High Court judge all the way through the bar, solicitors, legal executives, all those that work as legal professionals who will have had exemplary legal training. It's to give some complementary skills. There's no law involved, and so those in Scotland are just as welcome to sign up as in England and Wales, because there's no law involved. But it covers things like essential listening skills and the psychological impact of separation, the journey of loss, the Kubler-Ross journey of loss and grief, the different stages of development of children. It covers a range of skills that frankly are helpful for family lawyers to have, but aren't part of our formal legal training. And I must say, when I qualified as a solicitor, I practiced in the early 90s. I practiced for about 10 years until I took a career break when I had children, and someone asked me if I'd go along and help on their recovering from divorce and separation course that they were running to do the legal slot. So I thought, that's fine, yes, I could go along and, you know, it was of an evening, and do the legal slot. I sat in that room and I sat silently as a member of a small group. There were about 4 different small groups in the room as people shared their experiences, and I carried on being involved in that course, and I would say that I learned more that's been useful for me in this work, sitting in that room week by week and listening to those stories, than I ever did with my legal training, because there was so much going on that wasn't about law. So I think the reflex training is actually a really exciting development, and it comes straight out of one of the recommendations of the Family Solutions Group about the kind of broader expertise that all of us need. We all need to have, we can't be experts in everything, but we need to have enough understanding of these other fields so that we can support our clients in the way that they need. The other thing I wanted to mention is language. So as well as custody battles, we have an archaic system which is based back in historical days, when spouses litigated against each other as Smith versus Smith. The court headings are still versus Smith. The law reports are still Smith versus Smith. We have language which is unintelligible and which serves the vested interest of those in the system, but does not serve the needs of those who are vulnerable and who are using the system, who turn to the system for help. So the president of the Family Division is terribly keen for the language to be revisited, and asked us for a paper which is due to be published very, very soon. I'm giving you the heads up of what it says here. It says quite a lot in our paper, but basically we've come out with 5 Ps, which I think can apply to any legal system where we're dealing with families who are separated, who live apart. First of all, any language should be based in plain English so it is understandable. Secondly, it needs to be personal. It needs to talk about names of people rather than attribute them legal labels. Thirdly, we say it needs to be proportionate. It needs to be proportionate to the seriousness of the issues that are being considered. Now, clearly, if this is a highly serious domestic abuse case, there is a need for a certain formality and boundaries within the legal process, which create a safe system. Whereas if this is 2 parents who've just had a difficult falling out and can't agree about who's having Jimmy on a Saturday afternoon, we don't need such formality. The manner and the process needs to be proportionate to the issues being discussed. Fourthly, and very importantly, we need a problem-solving approach. It's the aim of the Pathfinder pilots. We need to move away from combative approach to collaborative. And that reflects the need to focus on parental responsibilities and away from parental rights. So that within that frame of shared parental responsibility, it stops being a tug of war and can take a shared problem-solving approach. So I think that's really critical. And finally, instead of being retrospective blaming about who did what when, we need to have language that is based around the positive futures for this family. Ultimately, our law exists to promote positive outcomes for every family member. And ultimately, we want children to thrive in childhood following separation. And so the language needs to point families forwards rather than to the many recriminations with a retrospective language. So we're excited about this. We're not quite sure what the president will do next with it, but he is very keen to have this debate. And in fact, he spoke about it on Broadcasting House recently. So that was really exciting. So that's what we've asked for, but who takes responsibility? Well, not us, that's for sure. All we are is a think tank that can say what's needed, but we have no resources and no power. We do have many supporters, though, from the top, the president of the Family Division, and through many members of Parliament. And in fact, the outgoing Lord Chancellor, Dominic Raab, was very keen to see change introduced. I'm going to finish with this slide, which says there is hope, because I think we always need to end on something positive. Where is the hope? Well, the good news is that there are now cross-departmental discussions going on between the various departments. The needs of families outside of a judicial system has been highlighted. There's greater awareness. No single department is willing to pick them up. The job is too big. But there are cross-departmental discussions with the idea, perhaps, of embedding more of this in local government. We held an event in March, which is where Ian came, where we met Ian. That was great. We called it Taking the Fight Out of Family Separation, and various people attended. The president's key phrase was, there has to be a better way. He is heavily pushing for support for families before they turn to court. And the Home Secretary, Suella Braverman, who was then the Attorney General, also spoke, and she said, we don't want families to end up at war. She's very clear about that, and pressed very skillfully by Paddy O'Connell at the end. She agreed to give her commitment to convene an event on better coordination and provision for separating families. So since then, she's had a fairly busy time. She's no longer Attorney General. She ran for head of the leadership of the Conservative Party, didn't get it, but she's now the new Home Secretary. But I think we need to follow that up with her. Meanwhile, we have a new Lord Chancellor, and we are waiting, I think, at the moment for him to find his feet and hear whether he intends to continue the initiatives from his previous predecessor to push through some of these moves. So that's us. I've included here the link to our YouTube short film. It's just a tiny short film of children's quotes. When you get the PowerPoint, I'd encourage you to have a look. You know, in any talk like this, we need to ensure that the voice of the child is heard. And it's just some direct quotes read by children, and it's very powerful and something that actually sometimes we share with parents and other professionals. So that's all from me, and I think we're now over to Amanda.
Yeah, well, thank you very much, Helen, for that very interesting presentation. Lots of ideas there. We are a separate country, and a lot of the things you've talked about are different in Scotland, but this question that you posed, who takes responsibility for the needs of the separating family outside of the justice system, that's just as relevant to us, even although the key players are somewhat different. Go away. Go away.
The joys of tech.
Yeah, no, I know. Okay, so can I now introduce Amanda Masson, who is the partner and head of the family law team at Harper Macleod. She has specialised in family law for the majority of her career. She's accredited by the Law Society of Scotland in family law, child law, and family mediation, and she's a regular speaker at professional conferences. Last time we invited Amanda to speak for us was at the launch of our new name, Shared Parenting Scotland, in January 2020. The main speaker at that event was meant to be Sir James Munby, who was the former head of the family division in England and Wales, but his train journey was blocked by bad weather and Amanda had to fill in the headline slot at very short notice. We have got all our speakers in place today, but can I ask Amanda to put the Scottish perspective in response to what Helen has just told us? And then after her talk, we'll start going through the questions and comments. So if you can fill in questions in the Q&A or even put them in the chat, we'll make use of that once Amanda's done. Anyway, let me bring in Amanda to give you her response.
Hello everyone, thank you so much Ian and Helen for inviting me to take part in this World Series. It's always just a real privilege for me to hear what other people are doing and to have a chance to talk about something that I am very enthusiastic about. I became a family lawyer because I wanted to help families and in particular children. So much of what Helen had to say chimes with our experience in Scotland. And all I really want to do today in response is just give some thoughts from a practitioner's perspective about some of the themes which Helen has raised and just talk a wee bit about what we are doing in Scotland. One of the things, Helen, that you said you're particularly kind, you talked about language. And I had a sort of memory or a flashback of court 20 years ago now, believe it or not, when a well-known Glasgow family law sheriff had said in the context of a hearing about what we would now term shared care, I think we need a new lexicon. Now I remember nodding vigorously, just as I was nodding vigorously, Helen, when you were talking about language. We are now 20 years on and I am ashamed to say that not a huge amount has changed. We still don't have our new lexicon. But what I think we can do as family lawyers, and I realise that most of us here today are family lawyers, is be very, very mindful of our own language and create the lexicon that will help families. Helen, I was nodding vigorously as well when you talked about an integrated approach. I would say in Scotland, sadly, our approach is not integrated for many of the same reasons you identify. We have lots of very, very well-meaning organisations. We have lots of sheriffs, judges who really care about family law, really care about the voice of the child. But someone, I think, needs to take responsibility for that huge job and bring everyone together. I was interested in hearing about the mediation voucher scheme. That's not something we have in Scotland. The main mediation organisation for solicitor mediators, CAM, have been looking at pilot schemes in the local sheriff courts. We've been talking a lot about what we can do to increase participation in mediation. The debate about whether mediation should be effectively compulsory or not has been raging for well over a decade. And again, I think the issue that we have in Scotland is just bringing together the people who have the time and the power and the resources to try to just effect meaningful change. Private mediation is quite hard, I think, to, dare I say it, sell to other solicitors, possibly because they perceive that they're effectively giving away work. What I would invite people to do, though, is just think a wee bit more holistically and think, look, we are in this to do a good job for clients. And if that means that we direct clients towards the more appropriate method of dispute resolution, financial karma dictates that things will come right in the end. That's a far bigger debate about, I suppose, the economics of family law. But as practitioners, I wonder if the way to think about this is perhaps in terms of corporate social responsibility, as well as the obligations that we have towards the courts, towards our clients, but also towards the children whose lives and futures we are effectively entrusted with, albeit in what seems to us lawyers as a fairly minor context. It's actually not a minor context. I know that in my child welfare report work, more and more I'm asked to talk to children, to take their views, to feedback to the court about how children feel. And their words are stark, they're direct, they have clear views. And my experience has been that those views often depart from the views that parents think their children have. And again, I would just invite our family law community to just think about that and think about how best to have the child's voice heard. If there needs to be greater investment and thought around child inclusive mediation, good. It's not something that should scare us. There are mediators in Scotland who are qualified to offer child inclusive mediation. And it's something that we should really, really think about as family practitioners. Who takes responsibility for the needs of separating families outside the justice system? I would say nobody at the moment. That's a personal and possibly slightly controversial view. But again, I would invite family lawyers to just think about their role. We can take some responsibility for outcomes for families. We can talk to clients about the dispute resolution spectrum. We are obliged now in terms of law society rules to talk to clients about mediation, and our obligation goes no higher than that. But sometimes in talking to clients about mediation as a possibility, we can really open client minds to positive possibilities rather than that more adversarial, confrontational system which so many of us get bogged down in. I wanted to highlight a system that we, an organisation that we have in Scotland known as the Promise. I'm not sure how many people will have heard about the Promise. I actually heard about it from my sister who works with Children First. And the Promise is an organisation which was established to try to bring together the organisations who have an interest in improving outcomes for children. Over 100 organisations, including Children First and some local authorities, have signed up to the Promise. Now, the promise that we are making to children is that they are entitled to grow up feeling loved, safe and respected, and able to realise their full potential. It's a laudable aim. The Promise is not specifically aimed at working with families who are facing separation, but many of the themes and the pledges, I think, are really relevant to the work that we're doing. And really the Promise promises to give children the right to a childhood. And it links in beautifully with some of the aims of the Convention on the Rights of the Child, to be heard, to feel safe, and to paraphrase, really to have a childhood that is not marred by conflict. The Promise is responsible for driving the work of change demanded by the findings of the independent peer review. But I think there's an awful lot that family lawyers can learn from the Promise. It might be something that law firms want to sign up to, I don't know, but again, it's just something that I would ask people to think about. It was launched in March 2021. It's a great thing to think about if we're trying to think about key aims and themes. Why are we doing this job? We're not just doing it to make money for ourselves, to make money for our firms. We are doing it because it is vocational. What we do is vocational. We wouldn't be in it otherwise. It's a stressful, it's a difficult job. It has to be something good that comes to what we do. I wanted to just say a few words about the new Act. And Ian is well aware that I think personally it was just a huge missed opportunity. The consultation period was very thorough, it was lengthy, it was so comprehensive, and I think many of us really thought this will be a chance for Scotland to really change the system of child law. it didn't go far enough in my view. But if we have time, Ian, I wanted just to say a few things about the new Act, where the opportunities were and where they still are, because although I do believe that the Act didn't quite go far enough, there is some good stuff in there. So if we have time, I will just say a wee bit about that.
Yes, yes, please do. Yep. Yes, you can certainly give us the points on the Act. There's a slight gap every short while. Your voice fades out and then it comes back in. I think there's just something slightly dodgy in the connection. But anyway,
sorry about that.
It's okay. No, that's fine.
The new Act. So we in Scotland wanted to respond and develop a family modernisation strategy for the justice system. We wanted to overhaul things. But Scotland was also keen, remember, to incorporate the UNCRC into domestic law. The United Nations Convention on the Rights of the Child was technically incorporated into Scots law on the 16th of March last year. But as many of us will know, the Supreme Court was then asked to consider whether the Scottish Government had acted out with its competence. I could see Helen shaking her head, I understand why. In October last year, the Supreme Court unanimously held that certain sections of the bill did breach the limitations imposed on the Scottish Government in terms of the Scotland Bill, and the Scottish Government have been asked to reconsider the wording. The aims set out were clear. The intention was to improve family law and how the child's voice is heard, but also to ensure that the child's interests were at the heart of the system. The consultation around the new Act was very wide-ranging. It covered off obtaining children's views, commission and diligence, contact, cross-border cases, and whether or not there should be a protocol between the Scottish and English courts, domestic abuse court procedure, alternatives to court. The analysis of the consultation responses is well worth a read. It's on the Scottish Government website. It was published in May 2019. It really is worth a read. Some of the results are actually quite surprising. For example, only 50% of respondents, probably the lawyers, thought that there should be a presumption that a child benefits from both parents being equally involved in their life. Only 56% of respondents thought that the Scottish Government should take action to try to stop children being put under pressure by one parent to effectively reject the other. The more positive responses were around regulation of contact centres and sibling contact. And really what the legislature came up with was something that I would say is not representative of a wholesale change, but rather tinkering around the edges. The Children's Scotland Act 2020 provides additional safeguards for vulnerable parties, including children. It sets out an expectation of increased training and regulation of court-appointed reporters and curators ad litem. The welfare test has been reworked. It hasn't changed hugely. And those of us who trained, I suppose in my era, might remember being taught the child law mantra, which was formulated by Elaine Sutherland quite some time ago. The mantra requires that the welfare of the child is paramount. We have the no order principle. Order should only be made if it's better to be made than not. And the child should have an opportunity to express a view to which the court shall have regard. Now, if you look at the new Act, it's horribly cumbersome. It really is almost nightmarish to try to sort of understand how the subsections and the new additions and deletions fit. I have a very lengthy transcript, which I'm happy to share with anyone who wants it, that just tries to make sense of the old law and the new law. However, in summary, I would say that the new law does not necessarily represent a significant departure from existing practice as it was before the Act came into force. There are an awful lot of things that still need to be worked out in Scotland. I have heard nothing about, for example, the regime for regulation of contact centres or training for child welfare reporters. There was nothing done about trying to increase participation in mediation, for example. There was nothing really done about trying to promote the idea of shared parenting. And I suppose I just want to finish where I started. We family lawyers do arguably have a huge amount of responsibility, but we also really do have an opportunity to affect outcomes. And again, I would just like to reiterate the invitation to my colleagues to really think about what we're doing and how we can, by the use of, for example, highlighting alternate dispute resolution strategies, the use of parenting apart classes, access to resources such as divorce coaches, really try to take a more holistic view for clients who will almost have been conditioned into assuming that separation has to be adversarial. It doesn't. I would really be interested to hear others' responses, thoughts. Does anybody have any updates on what Scotland are hoping to do anytime soon to bring those terms of the Act into force? I certainly haven't heard anything. Ian, you may have updates that I don't yet have.
Yes, great. Well, thank you very much, Helen. Sorry, Amanda. Thank you very much for giving us that approach. And obviously, you brought out various things which are very relevant to us in Scotland. Now, I do have a Q&A showing up now. This is one of the worries. Great. I was worried that the question and answer process wasn't working, but I've now seen one of them. Let me just, before we go to some of the questions, let me just give a couple of points in relation to what's just been said. We actually had a meeting with the civil servants in both family law and children and families this morning, and the staffing within family justice has been lower than it should have been over the last really 2 years, and they're working on the various points that were brought in the Children's Scotland Act 2020, but they're still quite a long way from bringing in these major proposals. They were talking this morning about possibly implementing some bits of the Act separate from the large sort of processes. And they were also talking about having an update to the family justice modernisation strategy, possibly by the end of this year. So we live in hope, but we are critical of the fact that we put all this effort into lobbying on a family law. We did get one in 2020, but it's not just because of COVID. There are other, we are really lacking the actual changes, and we want to go much further than the changes. Helen mentioned integration between professionals, and a couple of the talks we've got later in the series will mention what has happened. For instance, Philip Marcus, a judge and retired family judge from Israel, will talk about how they've brought social work professionals right into the start of the process in court. And also Celia Lillo from Montreal in Canada will talk about how they've brought the social workers, the lawyers, the therapists, the mediators, and the judges working together, particularly on the very high conflict cases where children sometimes refuse to see one parent. And Montreal seems to have found an approach to that which has had more success than in other places. So certainly these are highlights to be look forward to. Now I'm just trying to see. Yes, I've got one question that has been posed in the Q&A, and what we could do. I'm really not sure if are people able to post in the Q&A, or if not, we could actually open up and allow people to talk. Let's see. Let me go to the question that's there anyway, which is, are there any areas of English family law system that we should campaign to bring to Scotland sooner rather than later? So what are the good things in English family law that we should be having? Amanda, Helen, would you like to sort of comment on that?
It's a really interesting question, because just the kind of phrase, what are the good things in English family law? And I've spent most of my last 10 years trying to change the way in which it operates. But where are the positives? I think that the MIAM system is good if it works properly, if it's set up properly. It wasn't set up properly at the beginning because it was drafted in a rush by people at the MOJ who were not practicing mediators. And so some of the pitfalls weren't sort of spotted, and it hasn't worked well. But I think if it can be set up as a system where the MIAM operates to safe standards, and where there is an expectation that both halves, both of the couple, will come to see the mediator separately and have that discussion, then I think that's valuable. I think that is a valuable system, because I think most people don't know what the options are for resolving their issues away from court. I'm not in favour of it being called a MIAM. I think that's a mistake, because just calling it mediation information assessment meeting presupposes that we're sending everybody to mediation, whereas actually what it really is, well, it's lovely to see everybody joining, what it really is an information and assessment meeting where mediation is discussed alongside other options for resolving issues. So it is that triage that we think is badly needed. So I think taking the MIAM system, removing the term mediation and just calling it information and assessment, and where it happens where both parties, I shouldn't use that term, but both members, both halves will meet the mediator before a court proceeding starts, is a good system. I think it's a good system. It was set up with flaws, but I hope we're getting it right, and I think that's good. The other thing which has been fantastic is the mediation voucher scheme. It's cost some money, but when you think of the amount that's spent for every single case that ends up in court, I think there's a saving, because half the people wouldn't have even tried mediation had there not been for the voucher scheme, and 75% seen their issues resolved. So if you do the numbers, you know, it's saving money. So I think the mediation voucher scheme is a resounding success. But I think that's more about a political thing rather than law. You know, that's not that's no change in family law. That's the MOJ has introduced that, if that makes sense.
Okay, what I've been trying to do is to just add our attendees to the process. I still don't know whether people can actually talk. This is where I'm afraid we're learning how these things work. But and I see I've got another question. Great, I've got another question here. Somebody's saying, in my personal view, the issue of the legal funding of child law cases in Scotland having a huge impact on the way child law is dealt with. This presumably is the legal aid funding. Those who can obtain, those who can obtain legal aid funding are given very few alternatives to litigation, and thus are almost forced into court. Those who cannot obtain legal aid funding have the opposite, as they're almost prevented from accessing the court system, although they're still not migrating towards mediation in their droves. So, and quite rightly, this question points out that there are differences with legal aid funding in England. Now, legal aid funding in England was largely withdrawn, apart from domestic abuse cases, in about 2015, 2014.
2012, I think.
2012, well, yes, and
LASPO,
yeah, and that had a catastrophic effect, I think, in the courts, because you got lots of unrepresented litigants. But we still have legal aid, but it has both a means test and also a sort of prospects of success test to it.
The merits test, we used to call it.
Yes, that's right. Yes, but so. I mean, So you've got a slightly different atmosphere in the English court system, but you still have these problems of people either not being able to afford to go to court or not understanding the system.
Well, I mean, you're absolutely right, Ian, when you say that what happened was that people turn up in court unrepresented. And what was happening with legal aid was that people would meet a solicitor, and the solicitor would say, you know, this isn't really a case that should be going to court. You need other support. May I suggest mediation? And of course, if the solicitor suggests mediation, the client takes it seriously. And lots of cases were going to mediation. So you remove that conversation with the solicitor. And we had about half the mediation services under legal aid contract go out of business after last vote. So it was an unthought through and an unforeseen consequence. And the numbers of mediation that was legally aided dropped off a cliff. Obviously, privately funded mediation was not affected by it in the same way. But then what happened was that they got nowhere to turn. They can't go to a lawyer. They don't know about mediation. They don't like the sound of it if they do know about it. But the court application is only £215, cheaper than anything else. So they go to court, unrepresented. So then we have the Judicial College having to do emergency intensive training to all judges about how to deal fairly with litigants in person, using different language and explaining things. Each case takes longer. So, you know, the volume of cases going to court increased, and the length of time that each court case needed increased. Ultimately, using, you know, these judges as sort of semi-mediators to deal with all these unrepresented people. So it backfired massively. And that is one of the reasons why I think the MOJ is now looking at other ways. But there is this problem, and I don't know if you have it in Scotland, which is this absolute inability for a ministry responsible for justice to make provision for anything that happens before an application to court is made.
Right.
You know, if you take away legal aid, you've got to put something in its place. You've got to have some clear information and signposting. I mean, we would be really keen for the initial green form advice, you know, that initial conversation to be funded, you know, without having to establish domestic abuse. The other thing is that it places such a terrible emphasis on the power dynamic where there is domestic abuse. Clearly those who are victims of domestic abuse need legal aid and they need protection, and I'm not saying anything else, but it creates a power dynamic, and there are the wrong type of litigant who will try and get over the line for the domestic abuse because it opens up the legal representation, and that creates a very unhealthy dynamic as well. It's been an unmitigated disaster in my view. And the other disaster is for them over many years, notwithstanding we had the Voice of the Child report come out in 2015 with very clear recommendations, the refusal to fund child consultation, notwithstanding the improved outcomes on mediation outcomes and on families that is established by child inclusive mediation. And so not to fund it is counterproductive. I don't understand why. So I think there's, and I think it all perhaps falls into these silos where you've got civil servants who aren't talking to mediators enough and who aren't talking to judges enough, and too many people operating in silos and no kind of united thinking. But that's where it's been different over the last couple of years, is that these groups have got together to have kind of shared think tanks. And I think that we are seeing some benefits. It's desperately slow though.
Yeah. Well, I mean, our legal aid has two different types. There's advice and assistance, which can then move into representation. So there is legal aid available for advice and assistance. There was also a consultation issued by this legal aid board very recently about whether they should put a lot more things into the standard procedures for legal aid rather than being extraordinary. Things like mediation, supervised contact, and we would also suggest training and family therapy should be included into the standards that legal aid could cover. And we would far rather see a lot of legal aid money being put into this pre-court support rather than going towards the court process. But Amanda, do you want to comment on those things?
I really would agree with all comments. I think the legal aid system just does not help what we're trying to do. I can think of so many cases where one party has legal aid, one doesn't, and it just creates a problem in terms of having children heard. I think when it comes to child welfare reports and also mediation, because one person might well want to go to mediation partly because they think it's more cost effective, and the other parent just can't secure the funding for it. I have done some mediation under the legal aid scheme and quite often end up just saying I will just continue for free because there is no proper funding in place. I know that the mechanism for trying to get increases or secure more than the template sanction can be awfully cumbersome for agents. The system just seems to be broken. When it comes to children's views, we also have that mismatch because if one parent is privately funding, they are very, very conscious of how a child's view will be taken. If the other person is on legal aid, again, agents have a huge fight on their hands with SLAB when it comes to securing sanction for reports. And my experience here certainly has been different sheriffs do things very, very differently. There was a period where sheriffs would specifically ask child welfare reporters to take views, and that was it, because there was a recognition that having reports that narrated parental views might just exacerbate conflict. But we seem to be back into the era of very comprehensive child welfare reports where every member of the family is spoken to, including the child. And then there is a funding issue. It just doesn't seem to work. And again, my only, I suppose, potential solution would be that somebody sort of take the whole system by the scruff of the neck and really think it through.
May I ask another question, just related to child consultation, which is, you know, we're all very aware of the need for children to be consulted, or young people, when their parents are engaged in mediation and indeed in any court process. But there are many cases which are resolved through the private funding of two solicitors. They may be handling finance cases, or they may be helping their clients to agree arrangements for their children. What systems do you have for young people whose parents are using privately funded solicitors to be consulted and for their views to feed into that process? Because it's something we haven't yet got off the ground in England and Wales, but it's a large number, a large cohort of families who don't go to court, but who have legal assistance, and their children are routinely not only not consulted, but it doesn't even occur to anyone to consult them.
Well, some of the family mediation organisations in Scotland, particularly Avenue, but I think some of the others will do child consultation as well as the child welfare reporters doing it. Sorry, do child consultation as well as sort of family mediation. And I think Avenue have led the way in developing those sort of processes. And I think the courts in Aberdeen and Aberdeenshire will tend to ask Avenue to do it rather than going for a child welfare reporter. But that's, again, it's very, as Amanda says, it's patchy. It varies across the country. And
it would be good for all of us who work in the field of family separation for it just to be routinely expected that whatever context the family are working in, be it mediation, be it court proceedings, be it negotiations between solicitors, that there is just an automatic expectation that any child over the age of 10 will be consulted and their views taken into account in that process. And, you know, just as normal. Just, you know, now we all wear a seatbelt. It's just normal. We get into a car and we wear a seatbelt. And actually, a lot of our cars beep at us if we don't. We need a kind of file beep. That alerts us, has this child been consulted? Oh, I need to ring a local mediation service and get one of their child consultants to hear the voice of the child and then feed it in so that we, the solicitors, can take it into account in the work that we're doing with their parents.
Yes.
It seems such a no-brainer, but you know, it's not
Yes.
where we are in England and Wales for sure.
Yeah. Well, and if the UN Convention on the Rights of the Child is fully implemented in Scotland, if they can get over these legal hurdles about the powers of the Scottish government, then that in turn would put a lot of obligations on public authorities to do things.
Yeah.
And so
We need that.
Yes, well, that certainly would be a great sort of move forward. And we just don't know whether they can enact the law in a way that it'll pass the Supreme Court. So we're into a devolution tangle there. But anyway, now there's a question coming which actually gives me a nice prompt to talk about it's asking about, are there any organisations that provide shared parenting courses in Wales to guide and help parents on the way forward after separation or divorce? Now, I don't know whether, Helen, you've got any idea on that, but what I would say is that Amanda has also already mentioned Parenting Apart, which is a course that's offered by quite a lot of the local mediation organisations. Shared Parenting Scotland has been piloting a different course which originates in America, and we'll actually have another webinar in this series all about it, but a course called New Ways for Families. And that is a training program which we're going to be making widely available in Scotland next year, to help parents to understand the processes, to give them better communication tools, and to help them interact both with their ex-partner and with their children. So we'll be very interested to, once we've made that available. But I don't know whether we have any knowledge of what courses are available in Wales.
Well, I can't speak about any face-to-face courses that I'm aware of in Wales, but what I can say is that there are zillions of these parenting courses,
yes.
masses and masses of them. And the other thing is that since the pandemic, many of them are available online. There is a fabulous resource called What About Aruna, run by Mums and Only Dads. There is the Co-Parenting Way, which is launched by the Co-Parenting Way, Marcy Shaw, an online course. There's the Co-Parent Clinic. There are, I can send Ian, I can send some links.
So
the other thing is that the Reducing Parental Conflict program that's delivered through the DWP is working through a number of local authorities throughout England and Wales, and they are funding some specific, they call them interventions. I have a slight issue with the language, because when I'm separating, I don't want an intervention, I want support. But they call them interventions, but they have a number of interventions for parents who are struggling with conflict, many of whom obviously are separating or separated. So there are masses and masses of them, and one of the things we're working on at the moment is to try and establish a national association of separated parenting programs, so that people will, go on them, know about them, go on them. Wales, England, Scotland, again, just the fact that we have a different legal system doesn't mean to say that we have to have our own bespoke parenting. The parenting is the same. Yes. Needs of children are the same all over. So I can certainly share some of the links of those online ones. So I don't know if it's interesting, but the SPIP is what we have, which is the one approved by CAFCAS here in England and Wales. And a friend of mine runs it for RCJ Advice, and they have just had the survey response from 300 attendees recently. And when asked, will this course have a positive impact on the child, about 79% said yes. Would you suggest somebody else in a similar position attended this course? 97% yes. Do you wish you had done this course earlier? 86% yes. So you're really positive. And these courses, a bit like the speed awareness courses we have here. The only thing about a speed awareness course is it presupposes that one has done something bad, you know, in terms of speeding, and we don't want to give any loaded language here. We want this to be uplifting and positive and point people forwards, and talk about thriving childhood. So we don't want loaded language, but there does need to be an expectation that when parents separate, there's some useful information it's helpful to know that will enable your child, you know, to thrive in the rest of childhood with parents who live apart. So I think all the online resources are fantastic, and there's zillions of them. Actual ones in person in Wales, I can't speak to, and it's difficult because how do you find them?
Yeah, no, well,
without a website.
Sure. Well, New Ways for Families that we do is a mixture of online training and one-to-one coaching, and we've recruited quite a number of family lawyers and mediators and social workers to do the coaching in Scotland. And I think just relying on online is not necessarily enough, just watching something on screen. But if you can watch something on the screen and learn from that, and then talk about it with both a skilled coach and other parents, that is a good. And Parenting Apart has this interaction between parents. Some countries do have compulsory training courses for divorcing parents. I'm not quite sure whether you can do the same thing for people who aren't actually going through a divorce process, but making it available, making it widely available, and as you say, Helen, don't make it a penalty or a you know, it's not punishing people for separating. No. It's helping them.
Yes, it's not an intervention either. It's meant to be a helpful support.
Yes, and we, well, and I think the really sort of startling sort of conclusion from these the surveys that you were mentioning, but also the surveys we know about from these training courses, is that they would recommend other people to do it. If 90% of the trainees recommend that other separating parents do it, that is a really strong sort of recommendation, and you know it is, you know, we will certainly do all we can to promote training, and I think it's, you know, every family lawyer can offer the information to their clients about this training alongside the representation they're doing, because there are two different things going on here. You're wanting somebody to actually help you sort things out, to guide you through the process, but it's well worth learning more at the same time. Yes. Okay, I don't see any more questions coming in. One thing that I was wanting to ask you, this reflex training. This is training for the professionals, not for parents.
No. It's for legal professionals. Yes. Essential skills training for legal professionals of all types.
And I mean,
it's been put together by a lady called Gillian Bishop, who's the senior partner of the retired senior partner of a very successful central London law firm called Family Law and Partnership. Yeah, and she has been wanting to develop a wider training base for family lawyers, because she's a family law supervisor, and she works with too many family lawyers who are stressed, who are feeling that they're dealing with clients with increasing issues of narcissism and allegations of all kinds of abusive behaviours and demands. And these family lawyers are needing to know how to establish boundaries, how to manage listening, how to understand the different areas of need that these clients have. And ultimately, these family lawyers are increasingly stressed. I mean, really stressed. And, you know, she said, we're putting people into situations with training on law, but actually the clients that come to us may need some legal advice, and there may be some legal work to be done, but there's a whole raft of other things, and we are not equipped or skilled, and it creates for a very difficult professional relationship. And she has got together with a range of other experts from different fields to put together a series of online training programs. Again, it's all online. You do it yourself. You complete 3 modules and you get a diploma. But But, you know, for the modern family lawyer, I think many of the younger people coming into our profession are realizing that this isn't just about law. And yet, you know, my son's girlfriend is doing the solicitor's qualifying examination course at the moment. And, you know, there's nothing, absolutely nothing about the wider needs of families who separate. It just doesn't come anywhere near their syllabus. And so, you know, for the younger members coming into the profession, doing something like the Reflex Essential Skills Training, which is not expensive, can be done in one's own time, but actually could be really transformational in equipping us to handle these cases in a way that doesn't turn us to drink and sleeplessness, stress, and all the other things that come when working lives become, you know, too difficult.
Amanda, is anything like this available for family lawyers in Scotland?
Not that I'm aware of, but I'll certainly be recommending it to my team. And also, when I get back to teaching on the law diploma, I will be highlighting this to the family law elective students as well, because I really do think it's invaluable. And it might also, Ian, be worth us talking to the Family Law Association in Scotland about highlighting this, because so much of it
I mean, just raising it. I don't know in Scotland whether there are moves towards family law supervision, but it's something that's really growing. Inevitably, it is those firms where there's a little bit of money that they can afford, you know, to pay supervision for their family law solicitors. And whereas, in fact, you know, it's probably needed across the board. As mediators, we have to have supervision. We have to have 4 hours a year, but our family law colleagues don't. And yet they're dealing with stressful, difficult cases, as we all are. And supervision can be really helpful. But anyhow.
And again, Helen, 20 years ago, Anne Holdick, who's a well-known mediator in Scotland, used to arrange for us to have supervision. Now, I worked with her a wee bit later on in my career. I certainly found it enormously helpful. It's just something that was never really carried on or picked up on by other firms, but I agree it would be really useful for us.
And
I think it's about I was just going to say, I think all of us need to recognise the wider needs of the people that we're working with, the parents and the children, the unseen children often, and how that impacts on us and who's out there, you know, to provide this more holistic response.
No, I was just going to say that Shared Parenting Scotland now has about 40 solicitors across Scotland who take turns to attend our group meetings and provide information. We find this is very useful to the people who come to our support meetings, because it helps them to understand what's going on, what happens in the local courts, all sorts of things. But we feel that it also provides a pretty good learning experience for the solicitors who come along. And we often get comments from them saying, oh, I didn't realize that happened, and I had never come across this, because we tend to get the people who are in the most extreme cases coming to us. We also get a lot of people from various minority, ethnic, Black sort of communities, and we feel that we are providing a bit of sort of post-qualification experience through this scheme, but we're also getting a lot of help from the lawyers who help us, and they can also put it down as CPD in terms of their own annual requirement. But yes, I think that we certainly will publicise this Reflex scheme, and because there's no reason why it shouldn't apply to Scottish people. I think the issues are common, and we will continue to look for other examples of this sort of stuff wherever it is in the world, because it's useful to help family solicitors. Great, good. Okay, what I was going to do, just to conclude, and wait a minute, sorry, we have one other question. Yes, from Joan Romanis. The raft of support, oh gosh, hang on, that's disappeared from my screen. Where has that gone?
It's in the answer tab, Ian, sorry.
Yes, I know. Wait a minute. The raft of support facilities and agencies is overwhelmingly... It's overwhelming. Would it be possible to obtain government funding for a centralised portal to guide professionals and clients to the most appropriate local support agencies?
Of course.
Yes, well,
I mean, this is crying out for a
yes.
centralised website, isn't it?
Yes, yes. Well,
Like the DVLA.
that's again, it's a lovely cue for me to mention one of the things that we're doing. We have raised this with government as a thing that they should be doing. One of the other talks in the series will be from the Netherlands. They developed, through the Legal Aid Board and other partners, they developed a scheme called Rechtwijzer, which was an online dispute resolution process with lawyers sort of sitting behind the online, which was very interesting, but just didn't quite gel. And I think there was some resistance from the legal profession in the Netherlands because they felt it was stealing their business. But some of the people behind Rechtwijzer have developed a new scheme, and I won't even give you the Dutch word for it because I can't remember it. But one of our talks later on will be Elizabeth, who works with this, and we're also going to ask her to see whether she could do a feasibility study for whether this process could be developed for use in Scotland, because I think people are using online processes to do lots of things in their life, whether it's to do with finding a partner, finding a holiday accommodation, finding, sort of buying things. If you're going to find your partner through an online processes, I think you might also be able to navigate the dissolution of that partnership in a similar manner. Maybe not a Tinder for divorce, but something of the nature. And we obviously need to remember the people who don't have access to online, because they may be some of the most disadvantaged, but that's not a reason for not trying to develop. There's another scheme that we know of in Australia, which again is doing these things. So we are raising the issue with government and trying to get a wee bit of money from them to try and develop something like this. Can I just ask for a final word from both Amanda and from Helen, and then we'll close because we're nearly at the 1:30. Any final words, particularly positive words? We want to be positive about where we're going forward. Helen, do you want to?
Well, yeah, can I reiterate my thanks for inviting me to take part in a discussion in Scotland, which is a real treat. I think there is hope. I think that many of us have a broader understanding of these needs that families have. And I think, as I say, some of the younger people coming into the profession are coming in with a much more holistic approach. We're all more in tune with mental health vulnerabilities, ourselves and our clients and their children. And I think we will see change, but I think, as ever, government is slow to respond, and it may be down to us, the practitioners, to lead the way for change, and then government will possibly follow. But there's a lot that's been good that we hear about in Scotland, particularly your attempts to get child consultation adopted and the UNCRC, and I can only apologise as an English person that we thwarted those attempts, and we were absolutely gutted.
Thank you for the apology. Amanda, any final thoughts?
Lots to be positive about. The fact that we are all here having this discussion and we are all on the same page as practitioners and people concerned and working for families just shows the level of commitment to change, which has to be good.
Good. Okay. Well, I would apologize for the fact that it's maybe we're going to try in future webinars to make it more interactive, maybe to bring in the audience as well as the speakers. I don't think that's worked in sort of sufficiently well today, but that's just us learning. I want to thank our two speakers, Helen Adam and Amanda Masson. Thank Harper Macleod for the support to the series. Thank you also to Fraser, who's been the person behind the scenes actually making some of these things work. He's on our staff, and he's now got the job of making the recording work as well. And thank you to everybody who's taken part in this event, because we hope that you'll find it useful. We hope you might try some of the other webinars, and obviously you can look at all the information we're going to send out to you now to supplement what you've heard this afternoon. So thank you very much. Thank you very much, all of you. That's the end of our first webinar, thank goodness. And we will be back in possibly the next, well, we'll let you know when the next one is. Certainly it'll be during the course of next month. We're confirming the exact dates to you as soon as possible. Thank you very much.
Thank you, Ian.